In this video, I want to take a few minutes to explain what mechanic lien law is when it pertains to home improvement contracts, especially when it comes to roofing and actually any really home improvement trade. This is all universal. So mechanics lien, contractors and home improvement providers and material suppliers can put a lien against your house if they're not paid. Anybody can put a lien on your house, even if you don't have a contract with that person. Let's say you hire a general contractor and a general contractor hires a roofer. The roofer can put a lien on your house. The supplier of the roofer, so if the roofer buys material for your house and has it delivered to your house, that roofing material supplier can also put a lien on your house. Now, this is not as scary as it seems, and I want to go down step by step explaining the different processes and forms you might see throughout the process and how to protect yourself and what this actually means. Now, first things first is any home improvement contract is required by the California State License Board to have what's called a notice to owner. I'm going to put a link in the description below as well so you can take a look. A notice to owner pretty much reads something like a warning about the property liens. Anyone who helps improve property but is not paid may place what is called a mechanics lien on your property. A mechanics lien is a claim against your house even if the contractor is paid in full, unpaid subcontractors, suppliers, laborers, and it goes into a long big contractual term. This needs to be in your contract. If a contractor removes this is actually against the law. So a lot of times in our contracts people will see this term and they'll be like, hey, this is unacceptable. This needs to be removed. If I were to concede and remove that would be against contract state license regulations. That's there to protect you. So make sure any contractor you hire has that warning. If not, that's the first red flag that, hey, something might be off because this guy's not following the law from the beginning. So bottom line is that terms and conditions in the contract is nothing to worry about. It has to be there. The contractor's not trying to pull a fast one on you. That's required by law to have that in there. The next one, which really freaks people out, this, like, you know, people get it the first time they get it and they start panicking, they think they're gonna lose their house, is what's called the California preliminary notice. Any contractor that wants to have the right to put a lien on your house sends you a preliminary notice. So in my example that I gave below, you hired a general contractor and the general contractor hired subcontractors. It's not fair that a subcontractor can put a lien on your house without you knowing about that subcontractor. So a preliminary notice is the subcontractor telling you, hey, Mr. Homeowner, Mrs. Homeowner, I'm here. I'm going to be working on your house, and if I don't get paid, I'm securing my rights to put a lien on your house. So this is done by both subcontractors and a lot of times material suppliers. The top of the form clearly states this is not a lien. However, it's a scary form that you get. It has your personal information on it. It has the real property owner's name. So let's say your house is owned by a trust. The material suppliers actually can research and find out, oh, okay, they're going to be putting that trust as the actual lien holder's name. And it also has a section on here where it says estimated price of labor, services, equipment, materials, blah, 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 blah. This is just an estimate. So a lot of times, like if a material supplier was going to put a lien on a house, they'll just round the figure up and they'll say, okay, $50,000. It doesn't mean you're actually getting $50,000 of materials delivered. It's just a ballpark estimate, and a lot of times it's rounded way up just to protect themselves. So again, that's a preliminary notice. If you receive one, now you got to have your antennas up. You've got to really figure out what's going on, because now this person's saying that they're doing work on your house. So this is not a red flag, but it's something to be careful of. If someone does not send you a preliminary notice, and by the way, this is called a 20-day preliminary notice, which what that means is within 20 days of starting the project, that subcontractor needs to give you a preliminary notice. If they don't, anything prior to that 20 days cannot be covered under lien law. So let's say a material supplier delivers materials to a job site, then 30 days later fires a 20-day preliminary notice. Any materials that they brought in the first 10 days is not covered under their lien rights. They lose lien rights on the first 10 days. After a preliminary notice is filed, it's 20 days prior to that. So a lot of times material suppliers and subcontractors will file their preliminary notices even before they start the job, which is the correct way of doing it. Now this a lot of times happens more on commercial larger scale projects. Generally subcontractors don't file preliminary notices. So if you're doing a project and it's a 3-month project and you haven't received any preliminary notices, that means only the prime contractor, only the contractor that you have a relationship with is allowed to file a mechanics lien. You don't have to worry about anybody else. The last thing I want to make make a note on this is material suppliers work one of two ways. They either trust the contractor so much that based off the contractor's credit and reputation, they'll deliver the materials without a preliminary notice. For example, 99% of our jobs are done that way. Our material supplier has a good enough relationship with us, our credit rating is high enough, and our collateral with them is high enough where they trust us enough to deliver materials without giving preliminary notices out. Sometimes we might get a huge project, maybe once a year, where the material supplier says, hey, we have to send a preliminary notice on this, and we say, okay, that's fine, go ahead and do it. And the reason I don't like doing it on smaller jobs is just because it freaks people out. You know, I'm definitely going to pay for my materials, so I'd rather the homeowner not worry about it. I'd rather homeowners not deal with it. However, a lot of smaller contractors, if they're just starting out in the business, don't have that ability, don't have the financial backing to do so. So the supplier is forced to send out preliminary notices. So if they don't get paid, they'll start filing liens. Next, we go into conditional and unconditional lien releases. You got a contractor that you're paying, and let's use an example of you have not received a preliminary notice. So the only person you have to worry about is the prime contractor. When I say prime contractor, I mean the contractor that you have a direct relationship with. You have a contractual relationship with that contractor. That contractor is defined in legal terms as the prime contractor. So prime contractors don't need to give you a 20-day preliminary notice because you already know about them, right? So if you hire a general contractor or a roofer or an electrician and you have a contract with them directly, that contractor doesn't need to file a preliminary notice because you already know they exist. You're the one who hired them. So now you want to protect yourself against this contractor having any lien claims against your house. You're going to use one of four forms. And this might be an overkill. This was used on commercial, larger scale project, public work projects, stuff like that. The first thing, a conditional and an unconditional release upon payment. So a conditional release means that you've paid them, but the check hasn't cleared. So if someone gives me a check, I can't unconditionally release them because what if that check doesn't clear? So I give them a conditional release upon payment, meaning that on the condition that this check clears, I'm releasing my lien rights. Then if you want to be super sure, after that check clears, you ask them for a unconditional release, meaning the check has cleared and there's no conditions, the lien rights have been fully released. Next, you have progress payments and final payments. That's pretty self-explanatory. So if you have a $100,000 project and you've given 5 checks along the way, those are all progress payments. So you can have a conditional release upon progress payment and an unconditional release upon progress payment. Then the final check is a conditional release upon final payment and an unconditional release upon final payment. The strongest, I would say, out of these 4 forms is the unconditional release upon final payment. So even if you haven't got any other form signed by your contractor, if your contractor gives you an unconditional release upon final payment, you're good to go. Because that means that he's received his final payment and there's no conditions tied to that release. If you're dealing with a smaller contractor and you don't want to deal with 2 forms, 3 forms, 4 forms, all you have to deal with is an unconditional release upon final payment, or a conditional release upon final payment works too. So as you're giving the final check, ask for a conditional release. It's a pretty simple form. It's found on the Contractors State License Board's website. That's really the only version that should be used. This is published by the Contractors State License Board. I'm going to put a link to it in the description below. You can just print it out, fill it out pretty easily. There's one section that's titled exceptions. So let's say there's a disputed amount. Let's say like there's a punch list item, or they did a small task, it's like $2,000. You can put an exception of $2,000. Everything is released except that $2,000. So at least most of your project is protected. Lastly, I want to discuss just within a few moments of the danger and not so much danger of mechanics liens. Everyone thinks that, oh, if someone places a lien against my house, that's it. They're going to take my house. It doesn't work like that. Mechanic liens are not that strong because the contractor is forced to file suit against the lien holder, lien holder. So if someone doesn't pay me and I have mechanic liens rights, I can file a mechanic lien on their house. That's not enforceable. I still need to file a suit to enforce that lien. So in reality, in my opinion, it's not that beneficial for me as a contractor to file liens, especially in Southern California, where I know 99% of people that own homes have some type of disposable income. What mechanic lien does is if that person has no other assets, it allows me the right to eventually force a sale on that house. Because that is, if it's a primary residence, usually the primary residence is off the table when it comes to any type of legal actions. All the mechanical lien does is, if I do file suit and if I do win and that person doesn't have money to pay me, eventually it'll get court ordered sale, like eviction and sale. That never comes to that. Most people just use, including us, mechanical liens as a scare tactics and to show people that, hey, we're serious. Know the information about it, know how to protect yourself. It's kind of like anything else. The more you know, you realize that, okay, it's not a horribly scary thing. Be informed so you make wise decisions, and make sure that your contractor is following all the rules. And if your contractor doesn't know about all these rules, that's a big red flag. They should have studied this, they should have known this, and they should be the ones that guide you through this process. Thanks for watching, and if you have any other questions, we have a video I'm going to link below as well on how to make sure you find the right contractor and how to check a contractor's license, because if you do those two things right, you'll never have to worry about lien law while doing your projects.